produce the people in court most of the time. But there was a, now you remember the COVID times, the IGP and the Honorable Attorney General issued a circular regarding this the drug cases and all these things, that where they wanted police to grant bail in certain cases, and certain cases produce the accused in court and not object to bail. So that sort of thing is there. So it's the only way you can arrive at some where the people are both happy. I think it should be a circular from the IGP. Bar Association should ask the IGP to issue a circular regarding these small matters. Then the police station, the OIC of the police station will take appropriate action in those matters. But it can't be a hard and fast rule, because some of these accidents and some of the drunken driving charges are grave charges.
Yeah, thank you. No, Mr. Veerakon, the question is, there is no uniformity. Certain police stations grant bail, certain police stations don't grant bail. That is my concern. So,
that is what I said. Then the IGP should issue a strict circular. So even these IGP circulars are not carried out by some police stations. Simple as that.
Yes. Mr. Zaruk, I would like to know, sometimes when it comes to Section 13 of the Bail Act, if there is an offence committed, purported offence or alleged offence committed by, if a person is arrested on suspicion for offence committed where the ultimate sentence is death or life imprisonment, you have to invoke the jurisdiction of the High Court. Now, this is a problem that most practitioners have, because we cannot give a specific time framework on when bail is granted. As you know, you have to support the application, the notice, objections, counter objections, and argument, right? And it varies from court to court and judge to judge. I don't want to cast any imputations on a judicial officer, but certain judicial officers insist that the non-summary is over. Certain certain judicial officers insist that the entire investigation is over. And as a consequence, there is disparity. Now, the Constitution says the liberty is paramount. The liberty of the citizen is paramount. All that is being placed. But once you get caught to this tangle web, it cuts across all the principles that we have studied, that the presumption of innocence, all is gone into. It is used as a sentence before he's been tried. How do you think we can sort this situation out, Mr. Zaruk, as a practitioner?
I think as far as capital offences are concerned, where the sentence of death, for example, or unless the act says that bail cannot be granted, in such cases, of course, when it goes up, let's go back to the reasons why bail can be refused. I mean, bail can be refused on particular points. Of course, in a murder case, there has to be some time taken to, for example, there can be the analyst report, there can be witnesses and all that. But basically, Section 14 applies there too. Section 14 applies there too, because bail can be refused only on certain grounds. One is that whether he will appear, or that once bail is granted, he shall abscond, and or interfere with the witnesses, commit an offence while on bail, or that there's going to be a public outcry. But the point is, the Criminal Procedure Code goes up. And in the Criminal Procedure Code, I believe it is section it's section, I believe, 115. It says that subsection 3, consequent to allegations that he has been concerned in committing or suspected to have committed or to have been concerned in committing an offence punishable under 114, 191 and 296 of the Penal Code. Of course, then the question that comes up that he cannot be released on bail. So, and he cannot be released on bail certainly not by a magistrate, but it's only he can be released by bail only in an application made in the High Court. So normally in an offence of a grave offence such as murder or homicide or for that matter treason or instigating someone to commit suicide, in such cases the courts would be hesitant to grant immediate bail. They will give time for the police to find evidence. For example, if the SOCO people have gone to the crime, those specimens have been taken, forwarded to the analyst, the analyst report has come. And matters like that. So, but I don't think that one has to extend it to the time whether analyst report, for the analyst report to come, or for that matter, whether it should be given at a time given after the non-summary is over. I think that's going too far. What is most important, sometimes judges ask whether have you started the non-summary, because they are very concerned about the fact that the evidence of the main witness has been recorded. Otherwise, they think that the main witness will be subject to, will be interfered, and his evidence, they'll be subjected to some interference. But other than that, except for the fact that it's a discretion of the magistrate. No, sorry, not the district judge, it's the High Court judge. The High Court judge to consider at what stage bail has to be granted. So if he had been in remand, certainly you don't expect bail in a murder case like in a non-bailable, in a bailable offence. Although it's bailable by the High Court, they will certainly take those matters take the gravity of the offence into consideration, and whether the police has got sufficient evidence or sufficient time to look into this grave crime, and then bring him, then produce that evidence, and at some point of time, the judge has to be satisfied that granting that evidence, granting bail is justifiable. Other than that, there's no reason why anyone should keep him for days or years in bail, except for this restriction that bail cannot be granted by a magistrate. It has to go to the High Court, and it's the discretion of the High Court judge. So normally they go on that principle that one cannot be, if no charges are brought on in the magistrate's court or in the district court within a period of 3 months. Well, if you have been in remand for 3 months and your indictment or your charge has not been framed more than the indictment, the charge, then of course you can make a claim for bail. But these are totally at the granting of bail in such cases at the discretion of the magistrate. And here, in exercising that discretion, he should be reasonable. He does not need to keep him for years or for 1 year. Of course, after 1 year, he can, in any case, apply for bail. And some judges do keep certain people if there is a multiplicity of offences, grave offences, keep till 1 year is over, and unless the Attorney General makes an application to remand him further, bail is always granted. So that is very important. Of course, there are cases where accused who are, or rather suspects or accused who have the possibility that he had been absconding for a long time. The police found him difficult for him to arrest him, or he surrendered to court after a long period of time. In such cases, judges exercise a lot of caution in granting them.
May I add something?
Yeah,
to
please
this?
do. Yeah.
Now, the way I see it, if you interpret the 1997 Bail Act and compare it with the era before the Bail Act, under the Criminal Procedure Code, in a murder case, if the plaintiff was not filed in the magistrate court within 3 months, the magistrate had jurisdiction to grant bail. That system was a good system, because what happens now is certain times the investigation takes a long time. So I think that all offences under the penal code, the Bail Act applies. So according to the Bail Act, Section 14(1) gives the reasons why bail cannot be granted, why bail can be refused. So if what I feel is now, even after 1 month, if the investigations are complete, you don't have to wait for the non-summary to be commenced or to be over. Bail can be granted. Because what I see is now, by experience, most of the murder cases in Sri Lanka, except for these gangland killings, are spontaneous matters. There's no pre-planning. It happens suddenly. So keeping someone in remand for 6 to 8 or 10, 12 months is absurd in those circumstances. So what I feel is now, if we strictly interpret the Bail Act, bail should be granted even in a murder case within a month or two. There's nothing wrong with it, because if it does not fall under Section 14(1), the bail has to be granted. Those are the only reasons that bail can be refused. Not investigations, or it does not talk about investigations, but police can be given a chance to investigate, say 2 weeks, 1 month, 2 months. So beyond that, what investigation can be done after 2 to 3 months? So my feeling is that there should be a uniformity where the high courts of the right around the country must think on these lines and act according to the Bail Act, interpretation of the Bail Act.
You are right, Mohan, but only point is most of the judges will not take that into consideration. You know, unfortunately, unless, of course, the police will say that, sir, we have no evidence against him, and therefore we move to discharge him, or on that basis. Otherwise, they will keep on, they will not make use of that provision which is there to on the basis that you are right. The High Court can grant bail at any time, but they will not. They will ask certain questions and find out whether there have been enough time to investigate and all. This is what is practically happening. Otherwise, of course, if practically, at least it takes at least 3 to 4 months that the accused has to be, or rather the suspect has to be in remand before bail is granted by these courts. These are our experience. I don't know.
Another question is, gentlemen, now, once you support a bail application and notice is issued, why do, there is ample time? There is sometimes notice returnable is after 1.5 months. During that time, can't the police send its objections, and immediately on the notice returnable date, can't you have the inquiry and finish it off?
You can do it. There's no
because
restriction.
that is, making use of the existing process which is in place, because the notice returnable takes 2.5 months or 2 months, then 2 to 3 weeks is given for objections, then inquiry. I think, gentlemen, this process can be cut short, and it can be, like the primary court ordinance, whereas under Section 66 application, where you file an affidavit within 2 months, 2 weeks, counter affidavit, that process being inbuilt within 2 months, you can telescope the period of 2 months. Don't you think that type of reform should be considered in respect of bail?
In certain courts, it happens. In certain courts, it happens. So that's what I said, that there's no time limit for bail in this, which offences that come under the Bail Act. They can be granted bail at any time. So that it all depends on the court. Like you said, there's no uniformity. In certain areas, bail is granted fast. Certain areas, bail is not granted fast. So that is that's a problem. So I don't know how we can iron that out unless you bring strict regulations, like in the 6 weeks application, 3 weeks to file affidavit, then counter affidavit, then order within that. But even there, it does not happen like that because of the workload that the courts have. Even the high courts have quite a lot of work, a lot of cases. So it's difficult to just grant bail within 2 or 3 months. But happily, for everyone to be happy, I think a maximum period of about 3 months in the murder cases and should be all right, because that was the situation before the Bail Act. So the Bail Act, though it says that bail is the rule, exception is non-granting of bail. Now, in the murder cases, they have the authority to not to grant bail for anyone. Even the bail act, even at 410, 314, if the police files saying that they are disarming the village, he'll threaten the witnesses, and he files a 1 or 2 police reports, he can be kept in remand for 1 year, even a simple charge like 410 or 340.
One, we are talking of cases in respect of capital punishment, where it comes in where the sentence of death is passed.
Yeah.
The only problem is, in such cases, I mean, you're quite right to say, but if there is enough evidence and the record, and if the prima facie case that has been established and there are main witnesses, the police need not wait for the analyst report to come or any other reports to come and say investigations are not over, therefore keep him in remand. They could immediately file the plaint and lead evidence at non-summary, and non-summary evidence is very summarily led most of the time. So they could go ahead and lead that evidence, and the analyst report is not taken to or is not challenged in the lower court.
Yes.
I'm talking about capital punishment case. See, in such cases, as you quite rightly said, within over a period of 3 months, or even if the non-summary has been, all the evidence has been led, and you await only the report of the, say, the DNA report or from Gentech, or you are waiting for the analyst report, you could certainly consider granting bail, as long as, of course, the court is satisfied itself that, and the police, of course, satisfy the court also in that matter, that of course the police will turn around and say that, look, there is a chance that he will abscond, the usual story, or he's going to interfere with witnesses, or there's going to public outcry. But well, if he has been there for 3 months and if there's no such thing, well, I believe the court should act in favor of the suspect, because the presumption of innocence runs. So that you cannot turn around and then grant bail. So I'm in agreement with you, but one need not wait till the analyst report comes or the evidence. If you have that evidence, lead that evidence immediately. So that should be the criteria. But unfortunately, that I'm talking only in respect of cases of the cases where capital punishment is. But for that matter, now look at the cases. We'll come to that later, perhaps, under the poisons and the drug cases. There is different. There, of course, it is specified that bail has to be obtained, and there the quantum matters a lot. The quantum matters a lot. And the quantum is determined by the analyst report. You know, the gross quantum is not taken into account. The quantum is determined by the analyst report. So there again, the question is, you keep the man in remand for a long period of time until the analyst report comes in. And if the quantum is certain, above a certain quantity, you don't get bail at all. You are kept in remand. Now, I know of a particular case, particularly if you go into the Nigambo and the Mahara remand process, you find, of course, the quantums are very high. They are in remand for over 4 or 5 years. And the trial is going on. In some cases, the trial has not even commenced. And apart from the fact that the quantums have been very big quantities, they were trying to smuggle out of the airport or whatever it is. So in such cases, more than the rule, the exception applies. Although the rule is to grant bail, the exception applies in such cases.
Another issue, gentlemen, that I would like to pose, which most practitioners have a daunting task under the Bail Act, is the Anticipatory Bail Act, because the Act is very clear. It says under Section 21, subsection 1, that you have to support the application after giving notice to the officer in charge of the police station. And, certain magistrates would dismiss the application only on the technical ground that you have not given notice. Or once you give notice by registered post, if you give notice, and at least you have to wait 4 days for the notice to go, or after 4 days they will come and the police comes and says they have not received the notice, or the notice has not, they have not received the notice because, and they disregard the notice because it has not come through courts. They insist that notice has to come through court. I mean, applicant giving prior notice before supporting is not acceptable. And on this, this is a biggest problem that anticipatory, when filing an anticipatory bail, one has this. But if you're lucky enough, if you can support it, and if it's a police date, you can give it to the prosecuting officer in open court. But certain judges don't allow that. Now, Mr. Zaruk and Mr. Virakon, how does one, most judges want it to go through courts. When it goes through courts, it surpasses the 1 week period, right? And when the police officers come to court, they say, yes, there is a complaint, but the investigation is not over. Therefore, the bail application is premature. The magistrates tend to tell you that the bail application is too premature and it is dismissed. And if you really accept one or two cases, landmark cases, exercising the anticipatory bail option has, I don't think most practitioners, you all gentlemen, will be able to appraise the audience better. Has it made any success, impact, other than to just bring it to the notice of the judge that we have come with clean hands?
My view on this anticipatory bail section is it's not used at all. Very rarely it's used. I have used it only once and successful only once in the last 26 years. Once only. I don't do anticipated bail applications now because invariably it gets dismissed. And there's no purpose in this anticipated bail section. The way I feel, it's like going to the Hilton Hotel. So you can take it from there. That's my view anyway on this anticipated bail.
I think that you're right, Mohan. Most of the cases end up with refusals. But of course, they don't take into consideration. It is actually the belief that I used in the act is that if some person has reason to believe, I believe that is the word, reason to believe. He, on account of being suspected, being believed on account of being suspected of having committed a non-bailable offense. That is what confers the jurisdiction. The question of belief, that he should be suspected of having committed, and that it should be non-bailable offense. Then he can come before court and always ask for it. But then you have to give notice to the officer in charge because he is the person who will come and object. But as you said, the officer in charge may not accept the notice if the accused goes and gives it, or someone on behalf of the accused goes and gives it. It has to be sent to the judge, and normally you should impress upon the judge that this is being taken, the court sergeant can take notice of it and serve it, or immediately serve it. And if you feel that the police officer is not going to accept it and delay it until he is arrested or whatever, then immediately go to serve it through the ASP of the area or the senior police officer, whoever overlooks that area. And then you could also ask the judge that, in view of the circumstances, that that a shorter date should be given. So other than that, thereafter it is that he will come and of course file his objections. The usual story is that a number of cases where even the police officer had the audacity to come and say that, no, I don't need him. He's not a suspect. And then after a few weeks, or few days, or few weeks, he'll arrest him without notice. You may be very happy about the fact that your client there's no case against the client. But then after 2 or 3 weeks, he'll be arrested and say, no, we have evidence against him now. And
Mr. Saruk, if I add something more, right? If we can ask for statistics that how many anticipatory bail cases are pending in the magistrate courts of Sri Lanka, we will get a better view of this.
You're quite right. There are hardly any at the moment. And very few cases are filed. And some of those cases are, most of the cases, they refuse anticipation. You are right, on that. But, well, the criteria is that, and that is the basis on which it should be decided, but not on any other basis. So if it is something, if this act has done more harm than good, or it is not being acted upon, as you quite rightly said, there's no point in keeping that section unless the courts are prepared to act on that, irrespective of whatever may be the views of the police officer or the officer in charge of the police station is concerned. If courts are not prepared to act on that, and the percentage has been less than even 9% or 10%, there's no purpose in keeping this provision, section 21, at all. Yeah.
Now I will be switching to the Public Property Act, gentlemen. In respect of the Public Property Act, another common problem that we are facing, it most councils face, I'm sure that you all gentlemen also have faced it in your years of practice. The ASP, the rank of ASP under section 8(1) of the Act gives a certificate. And, he verifies that it's public property and the damage to the public property is over 25,000 rupees. And subsequently, there are judgments to say that if there are 3 or 4 accused, the ASP has to take each accused independently, to see whether, because it's a draconian piece of legislation. So that's why the burden has been cast upon at least an assistant superintendent of police to evaluate the evidence against the accused and to see whether there is incriminating evidence. Then only he gives the certificate that this is so and so, and in respect of there is a nexus between the damage and the accused. Now, most commonly, there are 10-15 people arrested. Maybe principally initially first, then through a further report, they subsequently arrest another and another and another. But there is only one report. And the whole process under section 8(1) of the burden cast on the prosecutor independently to go into it is totally lost, because, and there is a judgment to the contrary that cannot be taken into consideration. An independent report has to be given. Mr. Veerakon, what is your take on that principle?
Yeah, public property matters. You have to have it. It's not exceptional circumstances in the act itself. It says in single, it says asamanya karunu. Then Public Property Act, once the ASP's report is filed saying that the value of the property or what is stolen or what is damaged is over 25,000 and it's a government thing, public property, invariably you have to have this asamanya karun to get bail, if at all. Otherwise, you have to make an application and go to the High Court. So what I feel is that the police, what they do is, if there are 5 or 6 people involved, even if they don't have eyewitnesses, they have not done any investigation, they just feel that this man had been there. If someone says that this man was in the vicinity or something, they bring all these people and put under the Public Property Act. So once they are brought to court, the magistrates won't grant bail. It rarely happens that the granting of bail in the magistrate court, unless they wait in the remand for about 6 to 7 months. Then the time will be considered and the bail will be granted by the magistrate court. So that problem is there. So I don't know how we can get out of that, because police will file one report saying that value is that. Even if there's evidence or not, they will bring all these people and they will be remanded. So that is a very difficult question to answer, and how we can get out of it is a problem. So it will have to be, police will have to investigate individuals. Individually, they have to be investigated, and the further report or the B report will have to have specific report saying what each one did, how he was a party to this. So otherwise, I don't see how we can get out of this.
Mr. Veerakon, now the question may sound very amateurish, but that's a problem that it has to be addressed objectively. What is exceptional circumstances? Because the exceptional circumstances, in my opinion, tend to differ from magistrate to magistrate, judge to judge. Don't you think we need certain clarity on that? Mr.
No,
Zarok,
but
you also can assist the audience on this. What is exceptional circumstances?
now, because of this COVID situation, the last 4-5 years, the appeal court has defined what are exceptional circumstances. So there are so many reasons. So you take all these things together, they grant bail on those things. That's the time, then the sickness, then the being the only breadwinner, then the investigation notes, what the B report says is not exact. So there are so many reasons, and even the COVID situation, they consider that also as an exception circumstance at that time. And overcrowding of prisons. Now at the moment, our prisons can hold 9,000, but there are 27,000 remandees in the prisons. So all those things the appeal court considers now, and they have the last 2-3 years, the most of the appeal court judgments have been very favorable because they have been granting bail in most of the cases, except for, like Mr. Saruk said, very where the quantities of the drugs, heroin or ice, have been very high. All the other cases, bail have been granted because, as I mentioned earlier also, bail is the rule. It's not, bail that we granted because remanding a person is not a punishment because they are presumed to be innocent till they are proven guilty beyond reasonable doubt.
Then let me move
That's
on to
correct,
the Antiquities Ordinance. Sorry, Mr. Zaruk, do you have
that's
anything on that?
perfectly correct. The whole thing revolves around this definition of exceptional circumstances, and each judge would decide. Some would say, well, look, these are normal circumstances, usual thing, then those are not exceptional circumstances. Well, if the man is sick, the remand prison will look after him, and if he's there, well, you can't help it. But of course, how long has he been remanded, and is the case pending, or things like that. But I believe, but that is because they are not complying with sections 114-15 of the Criminal Procedure Code. If they comply with section 115, then outline the evidence against every particular person individually brought in, whether it's a single person or multiple number of suspects. Then the judge can assess what is the evidence that is there against each person, simply because a man has been present there. Now, I know of one case where particular, that of course refers to the Antiquities Ordinance, where he was one of those people who were going to have a bath in the river with a bucket in his hand, or what, not a bucket, with his things in his hand. Then there had been some people who had been trying to do some illicit jamming or whatever. They were all caught in and brought under the Antiquities Ordinance because they said that they are going after some nidane. And on that, I mean, it took a long time, at least reporting facts to court. And that is arbitrarily, or rather very, very summarily reported. And when you ask for further report, the further report is just the same report that is being repeated. So there are no fresh evidence being brought in. In such instances, it is up to the courts to make a judicial assessment on what evidence that is there. The mere presence will really implicate on a mere presence. Can you say that he is involved in that particular crime, whether he had been whether it's antiquities or whether it is drugs or whether it is anything else or public property, whether he could be charged. So these are matters where the judicial mind has to be brought in and looked into it. So that is very important. So this is not happening. So that's what I said. The police should be encouraged to comply with section 115 of the Criminal Procedure Code, which they do not. They do not. They simply say that that further investigations are pending. So on that basis, you further remand it, but that is no grounds to extend bail or to keep a person in remand. Now, this is being done, unfortunately. These questions of exceptional circumstances, no bail being granted. Now, look at the Immigration Act, no bail. Antiquities Ordinance, no bail. Why? Why? because there, unfortunately, bail is used as a punishment, not as is used as a punishment, which they should not do. Because you feel that even, look at even the point of view of the injured person or the complainant, or as they call the vindicator, the man who suffered. Now, when the police tries action, it may be a 314 case, or a 315 or a 316. It is bailable. And if the police grant bail, what do they come and tell us? Now they think that they should not be granted bail. So he expects that that bail is a punishment. But bail is not a punishment. This is the whole problem. So, and also this goes on in so many other ways. So it's up to the judicial officer to bring in a judicial mind and to consider report that is being filed in court is repetitive without any new evidence, whether there has been the individual suspects who have been produced have evidence against him, and the circumstances have to be looked into. So that is a matter. That is why I say there should be strict compliance with Section 115 of the Procedure Code.
Yeah,
You were
another
talking
question
about
is, Mr. Zaruk, I think Mr. Veerokon will be able to also assist us on this, is the Antiquities Ordinance. Now, the Antiquities Ordinance, especially Mr. Zaruk, you would know as a practitioner who goes frequently to the south, especially the Gaul Fort and the Mathura Fort, which has been declared at a heritage site. What they do is, even if a resident makes a small alteration of their dwelling, the archaeological police, there's a police arm which is attached to the archaeological department, they file a B report quoting a regulation under the Antiquities Ordinance. Now, is that possible? Because it is my express candid opinion, it is only Section 15A of the new amendment of 24 of 88 and 18B empowers you to empowers you to remand the person and under exceptional circumstances, or to grant bail, or to invoke the jurisdiction of the Court of Appeal. What is your take on that? Because that is another problem, that especially it's a regulation where they say under the Archaeological Act they have made the
Antiquities
regulation.
Ordinance, not the Archaeological Act. It is under the Antiquities Ordinance. Now, talking about this Antiquities Ordinance is one of the most abused ordinances in Sri Lanka. Now, if you dig a latrine pit in your house, police can bring you to court under this act. Now, you're talking about the Gaul Fort. Gaul Fort is a heritage site. It's under the archaeological department. So you can't do any. What the Section 15A says, willfully destroys, injures, defaces, or tamper with any archaeological. Now, Gaul Fort, everything is under that, comes under that Antiquities Ordinance. So we take Gaul Fort apart. Then in Sri Lanka, a lot of places, people dig a well, they are brought to court. They try to break a stone, they are brought to court. Now, the problem is the police don't understand there are two acts. One is the Antiquities Ordinance. Then the next is the treasure trove. People don't dig for antiquities, they dig for treasure. And digging for treasure is not an offense. Under the treasure trove, there's no offense. It does not come under the Antiquities Ordinance. So where the Antiquities Ordinance is that jurisdiction to the magistrate court is given only when the Director General's certificate under 15D is issued, saying that this is an archaeological site. No, and archaeological artifacts have been damaged, destroyed, or stolen. Other than that, the magistrate court does not get jurisdiction. So what the police do is they arrest people for digging a well, breaking some stones, clearing some jungle, and under this Antiquities Ordinance, and they are produced on a B report where they can't bring them under a B report because till the archaeological commissioner says that is an archaeological site, there's no offense committed. So the most they can do is bring a report and produce them, remand them. Then once the report comes from the archaeological department, the director general report comes. If it's not an archaeological site, they can't proceed. The accused should be discharged. But there are cases pending in our courts for about 6-7 years under the Antiquities ordinance, where the commissioner's report says that these are not archaeological sites.
That is right.
Yeah, that is very interesting, Mr. Veerakon. That's a hell of a problem that most practitioners faces, especially in Anuradhapura, Polonnaruwa, that area. Even if they go, if they dig a well, or
Dig a latrine pit, you can reborn.
when they participate in some cultivation, and there are numerous cases that then subsequently the police go and arrest them, and they are not gracious enough to accept that they have done a mistake. They file a B report, and these people are languishing in remand for years. So, do you think do you think we have an option? I can remember when Mr. Palitha Fernando was Attorney General, under the Offensive Weapons Act, if any person has been arrested, you have to inform the Attorney General's office within 48 hours. You have to send the B report. The officer has to go with the B report. Because it was a totally abused act at the time. But do you think there should be the same mechanism in some way should be there, where the initial investigation under 115 of the Criminal Procedure Code, at that stage, should be the certain checks and balances?
Yes, that is what I said. Now, if they are bringing people for digging a well, latrine pit, breaking some stones, clearing some jungle on the charge of under the Antiquities ordinance, so then they must verify whether it's an archaeological site or whether any archaeological things have been damaged. That is why I said that these people should be produced under A report, because they can't be brought to court under a B report, because there's no offense committed till that report comes. So what happens now is they are brought under a B report, they are remanded. Then the archaeological department takes 2, 3, 4 weeks for them to come to the area and do an inspection. So if you can expedite the inspection as soon as the man is arrested, the report is sent by the learned magistrate. Then the archaeological department comes, they do a verification, and they give the report. So if the report says that this is not an archaeological site, people can be discharged then and there. If it's an archaeological site, they can be kept in remand. Then the appropriate action, you can go to the High Court and ask for bail. Most important thing is the 15D report by the Director General of Archaeology, saying that whether this is the archaeological site or not, or whether any archaeological artifacts and antiquities have been damaged, destroyed, or stolen.
Mr. Veerakon, in the absence of that report, don't you feel that first and foremost they have to do a comprehensive investigation before producing them?
Yes, you can produce them. You can produce them under an A report. No, you can produce them under an A report. Office is not known. They can be produced to court, but that report must come within 3 or 4 days. That is what should be expedited.
Right. Mr. Zaruk, do you have anything on that?
No, I think as far as the Antiquities ordinance is concerned, it's a very peculiar act. I don't know, it's something, and it's also draconian. I don't know why it has been brought into that fashion. I mean, while you are referring to Gaul Fort is a separate thing altogether, because it's under heritage. It's a heritage site, and it comes under, it's an archaeological preserve. It's more than that, unless, of course, some offense is committed under the Antiquities ordinance. The offense under the Antiquities ordinance are completely defined, or more or less, as what it is. But I don't know, because if there is a related to theft or to distribution of antiquity, that is a offense that can be triable by a magistrate, and you can fine. But what is most interesting is that the question is that when it comes to the Antiquities Act, bail was not granted. not even under exceptional circumstances. They were remanded until the trial is finished, over. So, in such instances, it became very rather tricky. And there were instances where this was compared with, there were two interesting judgments, if I'm not remembering, along with the Immigration and the Immigration Act, where again similar provisions apply. And because Section 47 of the Immigration Act said that notwithstanding anything said in any other law, certain offences committed under paragraph 45A and all that shall be non-bailable, and no person accused of such an offence shall in any circumstances be admitted to bail. No bail available at all. And they had said they had only the privilege that their trial should be given preference above the other trials, but that never happened. Taking the congestion in courts, all that, it never happened. So, there again, the amendment came up, of course, in 2006. But what is interesting is to say that Justice Saras Silva, in that case of Subradasa's case,
Yeah,
where
205
others were charged.
Yeah, that's the case.
There he said that is completely unacceptable, and that bail has to be granted. It should be considered as a non-bailable offence, and bail should be granted because it completely violates the fundamental rights.
That's a constitution. Yeah, he said that man cannot be kept in remand indefinitely. Yeah, that was what was said in the case. Yeah.
So what is interesting, Mohan, in this case is, I think today he's in the High Court. There was a very, very enlightened and a very good judge who was very progressive in his decision making in Kandy, your area. The doctor, he got a doctorate subsequently, Sumudu Premachandra. Can you remember?
Yeah.
Yes.
Dr. Sumudu Premachandra, I had to go for Antiquities matter before him. And I argued the same basis, and I brought in this case, Sumanadasa's case. And I said, look, if that applies there, the same argument applies here. And he said, yes, both cases are same. You have to treat this as a bailable offence. He's upheld. And they never went up in appeal. And there, of course, that became a accepted principle in that court where things were considered, that was considered as a non-bailable, which is quite right. And he did that decision was quite right. And it was never challenged. So, I believe this question of saying that no bail is applicable is unacceptable. It has been frowned upon, and it has been held. Judgment of Sarasila in the Subradasa case is very, very clear on that. So therefore, that such offences has to be granted as a non-bailable offence, and bail should be granted. But what is of grave concern is this question of exceptional circumstances. That is the one that creates all the problems, because exceptional circumstances is as long as the Chancellor's foot. You can interpret it in any way you want. So those exceptional circumstances are very law. For example, take in a case of say drugs. Now there, certain courts takes into account how long did you take to send the productions to the analyst. In certain cases, it has taken 3 months, 2 months, 1 month. Then the judge turns around and asks the police, why did you keep it for 1 month? Why didn't you take it immediately? Why have you kept it for 2 months, 3 months? So such instances were considered as exceptional circumstances, bail granted immediately. Then the delay in the Laladi's report coming in was also taken in as an exceptional circumstance, because one need not consider that into account to grant bail, because, I mean, it is like any other, say, a capital case punishment, like a capital punishment case that comes under capital punishment. So in such cases, I think once again depends on the judge and how he looks at it. Certain judges will look into the police and ask, why are you doing? Why have you not taken it up? Those are exceptional circumstances. So these are some of those aberrations and some of the problems that we in court, when we make bail applications, we come across. And depending on the court and depending on what the judges, what shall I say, his earlier judgments, which we generally get familiar with it, we have to make an appropriate application before that particular judge. I mean, it goes back to the famous issue that always what Mr. Early Perra used to teach us first. He says, hey, go to court, sit down, observe the judge, know your judge first and how you should make an application before that particular judge. So that is very, very important to know the judge's mind, how he considers things. And that is what, however much case law you will take and try to support, that might not be of any use. So this is a very important matter. I'm just telling you how these things could be interpreted by different ways.
Now, talking about this bail, now in Sri Lankan, under Sri Lankan law, there are no acts or nothing to say that bail cannot be granted. Now, the most draconian law is the Prevention of Terrorism Special Provisions Act. Now, under that act also, now bail had been granted. So that is the worst act. So there are no laws in Sri Lanka that bail cannot be granted. Now, this exceptional circumstances also, like Mr. Farooq said, now the appeal court has considered, there are so many things come under. So they, in a cumulative thing, they grant bail. Now, it has been very liberal these days. Now, most of the people are coming out on bail because the courts take exceptional circumstances, not one. They take 4 or 5 reasons together and they say that that is enough to grant bail. So that has been the attitude now. So I think that's a very progressive step.
Yeah, finally, one of the last question would be Mr. Zaruk on the firearms ordinance. Now that also has this Schedule C and Schedule D. So if there has been even if there is a prima facie case where it falls under Schedule C, the police will always incorporate in the B report the Schedule D as well. In that type of situation, both schedules are put. In that type of situation, the magistrate's hands are tied and you have to canvass the matter of bail in the High Court. How do you think that one could overcome a situation of that nature?
Now, there again, the question is no bail can be granted if it's an automatic weapon. If it's an automatic weapon and if they say Swang Kriya, that means no bail will be granted. Am I right on that?
That's right.
So, in such instances, now you must understand that at what type of a period that these laws were enacted. I think these were all during the height of the terrorism that was prevailing in the country. We had a war of 30 years, so at that time they brought in these draconian legislations. But unfortunately, in peaceable time of now, but of course now, most of the gang assassinations that are taking place, these motorcycle riders coming in, and most of them happens to be, unfortunately, ex-army officers, military officers, or people who have had experience in firing with firearms, who come on motorcycles and then wear helmets and then shoot. In such cases, of course, the only deterrence would be as a deterrence. Look, you possess an automatic weapon, you possess a firearm or whatever it is, it's going to be difficult for you to get bail. Of course, if it's a non-automatic weapon, it's easy. It's not easy, it's not that difficult, but it's certainly, if it's an automatic firearm, it's a big process. So there again, it's punishable with death, or you have to have a life imprisonment. So it is those circumstances that goes into it. So sometimes I must say that firearms are looked upon very automatic firearms are looked upon rather very suspiciously and more seriously by courts. So there is a distinction between for the firearms ordinance and those particular sections that it makes a clear distinction between
No, my
weapon.
point is, Mr. Zaruk, the question of automatic weapon now is very loosely interpreted by the police.
May I answer this?
You're right.
Yeah.
You're right. At the initial stages, they are loosely interpreted and they are produced and then say it's an automatic weapon and the judge remands you straight away. But
what happens is,
around and say,
Mr. Saruk, what happens is, they produce the gun and the accused to courts, and they ask for a government analyst report to see whether this is an automatic weapon or non-automatic.
That's
weapon,
correct.
or a repeater shotgun. Repeater shotgun and the automatic weapon are the two that bail cannot be granted by the magistrate court. Right then. So these automatic weapons have been in existence from the 18th century. Gatling machine gun, then machine guns. What an automatic weapon is, once you squeeze the trigger once, whole burst goes. That is an automatic weapon. A small pistol, all those other semi-automatic, all those things does not come under this act, the section D. So what the police do is, now police have been in existence for over 100 years in Sri Lanka. The policeman should know what is an automatic weapon or what is not a non-automatic weapon. Why should they have to ask the government analyst to find out whether this is the automatic weapon or a non-automatic weapon? So that is what they do. So invariably, till the report comes from the government analyst, these people are kept in remand. Sometimes the report comes, this is not an automatic weapon. So if the police are not aware whether it's the people who use the weapon are the police. They have been trained to use weapons. So they must be able to identify a weapon before they produce the weapon and the man in court.
Yes, Mr. Veerukon, now you're spot on there, but do we have a way out of this? Because I have come across many occasions. It takes over, prima facie when that is in the report.
Unless it's a rare one of a kind weapon, right? Police should be able to identify what it is. So it's best to train the police to identify an automatic weapon and a non-automatic weapon, unless it's a rarity.
You're quite right, Mohan. Once again, why can't the police be trained at the training school itself or classes be conducted? They can be shown the different types of automatic weapons. They know the difference between AK-47 and M16 or any of these automatic weapons. There are automatic pistols, and there are plenty of confiscated or sample weapons. I think the police should be trained to identify initially what is not automatic and what is automatic. And they produce even the ordinary repeater gun. As you quite rightly said, they think it's an automatic weapon. And they go and produce it in court. And they remand people indefinitely until the analyst says the otherwise. So the ballistic experts are in the government analyst department. No, ballistics experts can be in the ballistics, but they can be even in the army, they can be even in the police. But as you quite rightly said, policemen could, in every district or wherever they could be trained, or the SOCO officers can be trained. And then I think practically every big police station that have a SOCO unit, they can be trained and they can identify whether it is a automatic weapon or not. Why do you want the government analyst to come and say it is an automatic weapon? So this is the problem. So I think that would certainly cut down the period of being in remand or being non-remand for some time. So here every weapon that can fire off is brought in until the fire off repeatedly anything is considered an automatic weapon. So that is unfortunate, very unfortunate. I agree with one on that matter.
Mr. Veerukon, do you think some form of reform like the Public Property Act, where a certificate from an expert like a ASP, who has some knowledge, maybe
that
not
is
an
why they
ASP, a
send it to the
person
government and list.
should kick in
That
there.
is why they send to the government and list. And what my feeling is, government analyst not a weapons expert. There are so many weapons experts in the Army, Navy, Air Force, and the police. So they know what a automatic weapon is and what is a non-automatic weapon. I'll give a simple example. Recently, three accused of produced, two accused of produced, saying that they had a Smith and Wesson pistol. So they say that it's a pistol. So that, and they have asked for a government report on the pistol. So ultimately, High Court granted bail, but that is a simple thing. That is what they do. Police don't know. They can't differentiate between a pistol and an automatic weapon.
Yeah.
And nowhere is it said that you need. Nowhere is it said that the government analyst should certify me. Yes. The law doesn't say that.
Another question, Mrs. Zaruk, why does the initial B report in any offense, may it be bailable or non-bailable, in most occasions, the police says that the investigation is not over. The last sentence is the investigation is not over, therefore, to remand the suspect for 14 days. Where it can be a situation where absolutely not, now I'm talking about the regular bail act, where section 14 does not apply. It's like a automatic sentence they put. It's like cutting and pasting from a computer chip. Every B report, when they produce a suspect, they make that application. How does one, don't you think the Bar Association itself has to say make representations in this respect, because on the grounds of the presumption of innocence?
I think more than the Bar Association is the judicial, the what do you call it, the institute should teach the judges what it is. Because, for example, that is not a reason to refuse bail. Bail Act has completely, narrowed it down and said these are the 4 reasons under which you cannot grant bail. That he will abscond, he will commit another crime, there is a public outcry, or he will threaten witnesses. These are the 4 grounds. Nowhere, as he said, investigations are not complete, therefore you cannot do it. And when you say that, if investigations are not complete, therefore you remand it, then court should say, why do you say that? Then they will say, look, sir, investigate now because he can interfere with the witnesses. Oh, he can interfere, but has he interfered? Are there any complaints? Who made that complaint? What made you to suspect that he is going to? You are not a suspicion, it is just an imagination. Your own manakhalpika. So why are you thinking like that? Why are you thinking like that? So if you cannot complete your investigation, that means there is no evidence. That is something in favor of a man who is presumed to be innocent. I don't know. So this question of remanding people goes against the concept of all what we have held sacred so far, from the Magna Carta right down to the ICCPR, right down to the 13th, Article 13 of the Constitution. All this goes against it. So that is what it is. So today, very unfortunate, we are discussing events and occasions where bail is now used as a weapon of offense and as a weapon of offense. And you are remanding him, you are punishing him, and before he is being found guilty, not on the basis of that he will abscond, not on the basis that he will interfere with witnesses, not on the basis that there's going to be a public outcry, or not on the basis on which he's going to commit another crime, but on the basis that the police are not capable of completing their investigations purely because there is no evidence. The police are now remanding a person. You remand a person only on the grounds there is prima facie evidence. But what is happening here is they are remanding people and then searching for evidence. Normally, you will ask him to come on to the police station 2-3 times, record evidence, send him off home, send him home. Where are you there? Well, don't go out of your town without informing us. You are under investigation. You can keep at some point of time when they get enough evidence to establish a prima facie case only, then they should be produced on a B report to court. Now, not to produce them in a B report to court and they say investigations are not over, therefore please remand. Then the judges, then rather the courts, then presume investigations are not over. He might interfere with witnesses. Now that is the prejudice or the prejudgment, and on that basis, a man is kept in remand. I mean, completely for a long period of time. So it's very, very unfortunate.
Another important question that I want to ask you all gentlemen is certain magistrates insist on a Grama Sevaka certificate, within the jurisdiction of that court. Now, there can be a very innocent person having strong associated community ties.
No, that does not happen now, because that you can't do that. The citizens of our country they have an identity card and they bring a certificate from where they live. That is enough. So I don't think that is on the wane now. It does not happen now.
Yeah, that's earlier, of course, they insisted the witnesses should be, the surety should be from the same district, and also there was a new trend that was coming up, that you must have one of them should be a public servant.
Or a relation.
That's another question, Mrs.
Relations are okay. We can bring on a relative who is a public servant. Also, some of the public servants who came forward to grant bail were the sighted laborers and the scavengers.
Conservancy laborers.
Conservative laborers who were coming from the urban council, who were brought in as public servants.
Yeah.
So this became a joke. Why do you want to have what is so special in a public servant? It is that he should be the best are to have two close sureties who have the means to pay that. Okay, I can understand the Grama Sevaka certificate, but certainly then that became then you may be from Colombo district or Puttalam or some Vavuniya, but if you are charged in, say, in Gaul or Mathura, you have to find two sureties from that district, from Gaul district. Where can this poor man find two people who will stand surety for him within that district? But as you quite rightly said, now that there are identity cards, there are NIC cards, there are other means of finding people out. Why are you insisting on these things? These are some of the most ridiculous things that happened. And I hope, thank God, it is now waning. And judges are becoming more pragmatic and practical. So these are issues that should be taken up by the Judicial Judges Institute when they train these magistrates, most of them.
And another point, Mr. Zaruk, is certain instances they said to bring a Vatkam Sathiki, what call your asset declaration. Certain people, unfortunately, you put them in a very embarrassing situation. They say that you have to have so much of assets.
Because if you have, by chance he absconds, then the bail has to be if the surety has to his bail has to be confiscated, whether he has the means to pay that confiscated amount. But there again, bail has to be reasonable. You can't order for this amounts which a man cannot. It has to be reasonable. And I mean, ordering heavy bail is like granting is not bail. Is not granting bail. There are people who have been granted bail and who are yet in remand for months and years because there's no one to come and give them that bail. So, and nor are there cases taken up on a priority basis. I mean, these are some of the issues that are pragmatic issues, practical issues that are taking place. And another important thing is judges have to visit the remand prison once a month. I don't know whether those visits are taking place. I hope they take place. Then they will know the conditions of the prisons because, and normally today prisons are highly overcrowded and each remand costs about 1,005 rupees a day. Once upon a time, it was about 8 to 900, but today it's 1,500 rupees a day minimum to maintain a remand prisoner. In November, fair bail should be granted unless, as Section 14 indicates, that he is not going to interfere or it's going to create after at least for some time if there's going to be a public outcry or if he's going to threaten witnesses. So unless that, bail should be reasonable and there should be a reasonable amount. And it's like ordering heavy bail is like keeping him in remand, you know. So that is one of those events. And then people are now being remanded for civil certain offences unnecessarily. That, for example, now look at the case of Mr. Lalit Kotrawala, who died recently. Now he had gone to courts with his counsel, and he had enough money to play, and he said, "Look, okay, 25 billion. I have enough assets. I will settle this. But today, to express my own bona fides, I am prepared to pay come up with 100 million cash and the others in checks, a billion up to about $1 billion. Sorry, not a billion, billion. These are what the counsels who appeared for him told me. But bail was refused and he was remanded. And he was remanded for years. And there were multiple cases because his entire establishment crashed. But if he had been given that opportunity that day to accept that money,
Mr.
and then
Zaruk,
to pay
I'm
over a
sorry.
period of 1 year's time,
Mr.
you know,
Zaruk, I'm sorry. I have to interrupt you. The webinar, I am getting messages that the webinar is over.
Oh.
It's very, very interesting speaking to you all, gentlemen. Thank you very much. It has been a great honor, Mrs. Zaruk, to be. I have been associated with you, Mr. Veerapon. The first time that I've encountered you, it has been a great honor. We have been working very closely together. And I look forward in meeting and working with you all, both gentlemen. As a young practitioner, I think I will have I will gain a lot of experience, knowledge and experience in the practical aspect. Thank you very much and wish you all the very best in life.
Thank you, Vishwa.
Thank you very much. Thank you very much.
Thank you.
Thank you very much.
That's fine.
Thanks, Mohan. It was nice.
Thank you.